Dear students, I welcome you to yet another lecture on corporate law. The topic of discussion for today's lecture is the National Company Law Appellate Tribunal, which is called NCLAT in short. The constitution of the National Company Law Tribunal and the National Company Law Appellate Tribunal marks a paradigm shift in the field of corporate law in India. The intention of the legislature in establishing a specialized forum to adjudicate all disputes pertaining to companies in India was to provide a simple, speedy, efficient and more accessible dispute resolution mechanism. The formation of the National Company Law Tribunal and the National Company Law Appellate Tribunal is a milestone towards attaining speedy and effective resolution of disputes pertaining to the affairs of Indian corporates. These tribunals act as a single window for settlement of all company law related disputes effectively and avoid unnecessary multiplicity of proceedings before various courts or authorities. These tribunals provide holistic solutions to issues being faced by companies, including those of winding up, oppression and mismanagement, and insolvency. Being the only forum having jurisdiction over disputes pertaining to company law ensures that there is no scope for overlapping or conflicting judgments. With a mandate to dispose of cases before them as expeditiously as possible, the possibility of delays is also minimized. Dear students, we now have a look at the jurisdiction of the National Company Law Appellate Tribunal. The National Company Law Appellate Tribunal has been constituted under Section 410 of the Companies Act 2013 for hearing appeals against the orders of the National Company Law Tribunal. Number 2, the National Company Law Appellate Tribunal is also the appellate tribunal for hearing appeals against the orders passed by the NCLAT, that means the National Company Law Tribunal under Section 61 of the Insolvency and Bankruptcy Code 2016. The National Company Law Appellate Tribunal is also the appellate tribunal for hearing appeals against the orders passed by the Insolvency and Bankruptcy Board of India under Section 202 and Section 211 of the Insolvency and Bankruptcy Code 2016. Number 3, as per the amendment brought to Section 410 of the Companies Act 2013 by Section 172 of the Finance Act 2017, the National Company Law Appellate Tribunal is also the appellate tribunal to hear and dispose of appeals against any direction issued or decision made or order passed by the Competition Commission of India. Number 4, the National Company Law Appellate Tribunal is also the appellate tribunal to hear and dispose of appeals against the orders of the National Financial Reporting Authority as per the amendment brought to Section 410 Clause A of the Companies Act 2013 by Section 83 of the Companies Amendment Act 2017. Dear students, we now have a look at the constitution of this appellate tribunal. According to Section 410 of the Companies Act 2013, the National Company Law Appellate Tribunal shall consist of a chairperson and such number of judicial and technical members not exceeding 11 for hearing appeals against the orders of the National Company Law Tribunal. Dear students, we now look at the qualifications of the chairperson and the members of the appellate tribunal. According to Section 411 of the Companies Act 2013, the chairperson shall be a person who is or has been a judge of the Supreme Court or the Chief Justice of a High Court. A judicial member shall be a person who is or has been a judge of a High Court or is a judicial member of the tribunal for 5 years. A technical member shall be a person of proven ability integrity and standing, having special knowledge and experience of not less than 25 years in law, industrial finance, industrial management or administration, industrial reconstruction, investment, accountancy, labor matters or such other disciplines related to management, conduct of affairs, revival, rehabilitation and winding up of companies. Dear students, we now have a look at the selection of the members of the Appellate Tribunal. The chairperson and judicial members of the Appellate Tribunal shall be appointed after consultation with the Chief Justice of India. The technical members of the Appellate Tribunal shall be appointed on the recommendation of a selection committee consisting of A. The Chief Justice of India or his nominee as the chairperson. B. A senior judge of the Supreme Court or a Chief Justice of a High Court as member. C. Secretary in the Ministry of Corporate Affairs as member. D. Secretary in the Ministry of Law and Affairs as member. And E. Secretary in the Department of Financial Services in the Ministry of Finance as member. The Secretary, Ministry of Corporate Affairs, shall be the convener of the selection committee. No appointment of the members of the tribunal or the appellate tribunal shall be invalid merely by reason of any vacancy or any defect in the constitution of the selection committee. The term of office of the President, the Chairperson and other members. The chairperson or a member of the appellate tribunal shall hold office as such for a term of 5 years from the date on which he enters upon his office, but he shall be eligible for reappointment for another term of 5 years. A member of the appellate tribunal shall hold office as such until he attains, as in the case of the chairperson, the age of 70 years. In the case of any other member, the age of 67 years, provided that a person who has not completed 50 years of age shall not be eligible for appointment as a member. Provided further that the member may retain his lien with his parent cadre or ministry or department as the case may be while holding office as such for a period not exceeding 1 year. Dear students, we now look at the expeditious disposal of cases by the appellate tribunal. Every appeal filed before the appellate tribunal shall be dealt with and disposed of by it as expeditiously as possible, and every endeavour shall be made by the appellate tribunal for the disposal of such application or petition or appeal within 3 months from the date of filing of the appeal before the appellate tribunal. Where any application or petition or appeal is not disposed of within the period specified in subsection 1, the appellate tribunal shall record the reasons for not disposing of the application or petition or appeal within the period so specified, and the chairperson may, after taking into account the reasons so recorded, extend the period by such period not exceeding 90 days as he may consider necessary. Appeal to the Supreme Court. Any person aggrieved by any order of the appellate tribunal may file an appeal to the Supreme Court within 60 days from the date of receipt of the order of the appellate tribunal to him on any question of law arising out of such order, provided that the Supreme Court may, if it is satisfied that the appellant was prevented by sufficient cause from filing the appeal within the said period, allow it to be filed within a period not exceeding 60 days. Now, dear students, we discuss the procedure before the appellate tribunal. The appellate tribunal shall not, while disposing of any proceeding or appeal before it, be bound by the procedure laid down in the Code of Civil Procedure 1908, but shall be guided by the principles of natural justice. Subject to the other provisions of the Companies Act and of any rules made thereunder, the appellate tribunal shall have the power to regulate their own procedure. The appellate tribunal shall have, for the purposes of discharging their function under the Companies Act, the same powers as are vested in a civil court under the Code of Civil Procedure 1908, while trying a suit in respect of certain matters, namely, a. Summoning and enforcing the attendance of any person and examining him on oath. B. Requiring the discovery and production of documents. C. Receiving evidence on affidavits. D. Subject to the provisions of sections 123 and 124 of the Indian Evidence Act 1872, requisitioning any public record or document or a copy of such record or document from any office. E. Issuing commissions for the examination of witnesses or documents. F. Dismissing a representation for default or deciding it ex parte. G. Setting aside any order of dismissal of any representation for default or any order passed by it ex parte. And H. Any other matter which may be prescribed. Any order made by the appellate tribunal may be enforced by that tribunal in the same manner as if it were a decree made by a court in a suit pending therein, and it shall be lawful for the tribunal or the appellate tribunal to send for the execution of its orders to the court within the local limits of whose jurisdiction a. In the case of an order against a company, the registered office of the company is situated, or b. In the case of an order against any other person, the person concerned voluntarily resides or carries on business or personally works for gain. All the proceedings before the tribunal or the appellate tribunal shall be deemed to be judicial proceedings within the meaning of section 193 and 228, and for the purposes of section 196 of the Indian Penal Code, and the tribunal and the appellate tribunal shall be deemed to be civil court for the purposes of section 195 and chapter 26 of the Code of Criminal Procedure 1973. Power to punish for contempt. The tribunal and the appellate tribunal shall have the same jurisdiction, powers and authority in respect of contempt of themselves as the High Court has, and may exercise for this purpose the powers under the provisions of the Contempt of Courts Act 1971. Dear students, we now look at some very important judicial decisions. In Sameer Agarwal versus Competition Commission of India, the Supreme Court of India has observed that the doors of approaching the Competition Commission of India and the appellate authority, that is, the National Company Law Appellate Tribunal, must be kept wide open in public interest so as to subserve the high public purpose of the Competition Act 2002. The observation by the Apex Court came in its verdict on a petition challenging the order of the National Company Law Appellate Tribunal, which held that the informant had no locus standi to move the Fair Trade Regulator, that is, the Competition Commission of India, alleging anti-competitive conduct by app-based cab service providers Uber and Ola. In this case, the Supreme Court refused to interfere with the orders of the Competition Commission of India and the National Company Law Appellate Tribunal, which had held that Ola and Uber do not facilitate cartelization or anti-competitive practices leading to inflated charges for riders. In Hyundai Motors Limited versus Competition Commission of India and others, the Competition Commission of India found Hyundai in violation of Section 3, Clause 4 of the Competition Act for its resale price maintenance policy and tie-in arrangement vis-à-vis its dealers. The National Company Law Appellate Tribunal, however, set aside the order and directed a refund of the penalty as the Competition Commission of India had based its decision only on the opinion expressed by the Director General in his report, which is merely an investigation report and had not taken any analysis of the evidence to arrive at its finding of contravention. As such, the National Company Law Appellate Tribunal emphasized that the Competition Commission of India is required to apply its mind when arriving at a finding. However, the impugned order lacked evidence as well as analysis. In SP Velumani and another versus Magnum Spinning Mills India Private Limited and others, the appellant filed a case contending that bogus transactions and siphoning of funds had taken place in the company and filed a petition in the National Company Law Tribunal, Chennai, for prevention of oppression and mismanagement. After having heard the parties, the National Company Law Tribunal, Chennai bench dismissed the case, stating that the acts complained of are not falling within the purview of oppression and mismanagement. Being aggrieved by the order of the National Company Law Tribunal, the appellant filed an appeal to the National Company Law Appellate Tribunal. The contention of the appellant that during the financial year 2017 to 18, an amount of rupees 48,41,801 had been written off as bad debts, and the details as to the identity of the party, whether related party or otherwise, had not been disclosed. The National Company Law Appellate Tribunal upheld the decision of the National Company Law Tribunal, Chennai bench that the decision of the Board of Directors to write off the bad debt is a commercial decision which does not warrant any judicial interference. In Economy Hotels India Services Private Limited versus Registrar of Companies and another, Section 66 of the Companies Act 2013 states, a company limited by shares or limited by guarantee and having a share capital may reduce the share capital by passing a special resolution subject to the confirmation by the National Company Law Tribunal and alter its memorandum by reducing the amount of its share capital and its shares accordingly. The tribunal has the absolute power to confirm or reject the scheme of reduction. In the extract of the minutes submitted to the National Company Law Tribunal, it was written that the unanimous ordinary resolution required for reduction has been obtained. The National Company Law Tribunal rejected the application for reduction. Hence, the company filed an appeal with the National Company Law Appellate Tribunal, pleading that it was a mere typographical error in the minutes characterizing the special resolution as unanimous ordinary resolution, and the appellant had filed the special resolution with the Registrar of Companies and fulfilled all the statutory requirements prescribed in the Companies Act 2013. Hence, the order of the tribunal was liable to be set aside. Merely a typographical error in the extract of the minutes characterizing the special resolution as unanimous ordinary resolution will not render a special resolution as invalid. The special resolution is very well valid. The National Company Law Appellate Tribunal allowed the reduction. Tata Consultancy Services Limited versus Cyrus Investment Private Limited is a landmark decision on corporate law. The facts of the case are: Mr. Cyrus Mistry was appointed as the chairman of Tata Sons in the year December 2012. Subsequently, in 2016, in the board meeting of Tata Sons, he was replaced from the post of the executive chairman on the ground of trust deficit and repeated departures from the culture and ethos of the Tata Group Limited. Cyrus Investments Private Limited and Sterling Investment Corporation Private Limited, belonging to the SP Group, which in fact belonged to the Cyrus Mistry Group, filed a petition before the National Company Law Tribunal under sections 241 and 242, read with sections 244 of the Companies Act 2013, on the grounds of unfair prejudice, oppression and mismanagement. The allegations of oppression and mismanagement were: number one, the Articles of Association were per se oppressive as they ensured that Sir Ratan Tata Trust and Sir Dorabji Tata Trust controlled the affairs of the company. Number two, there was immense interference of Mr. Ratan Tata in every decision of the company. Number three, continuation of the nano car project undertaken by Tata Motors upon the insistence of Mr. Ratan Tata, in spite of it being a loss-making venture from its very inception. Number four, the removal of Mr. Cyrus Mistry as the chairman of the company was in violation of law, principles of governance, fairness, transparency and probity. Number five, the acquisition of Chorus at overpayment by Tata Trusts. Number six, transactions made with Siva and Sterling Group of Companies by Tata Group. Number seven, fraudulent transactions worth rupees 22 crores in Air Asia by Tata Trusts. The National Company Law Tribunal, Mumbai bench initially dismissed the petition under section 241-242 of the Companies Act 2013 being non-maintainable, citing that no cause of action was established in any of the allegations raised by the petitioners. Further, they did not meet the criterion of 10% ownership in a company for filing the case of oppression and mismanagement under the Companies Act 2013. On appeal, the National Company Law Appellate Tribunal gave its judgment in favor of Cyrus Mistry and set aside the order of the National Company Law Tribunal. The National Company Law Appellate Tribunal reinstated Mr. Mistry as the executive chairperson for Tata Sons for his remaining term and declared the subsequent appointment of Mr. Natarajan Chandrasekaran as executive chairman of Tata Sons as illegal. However, it suspended its implementation for 4 weeks in order to provide time for the Tatas to appeal. The National Company Law Appellate Tribunal order also set aside the Tata Sons' decision to convert itself into a private company. The National Company Law Appellate Tribunal was of the view that Mistry's removal from Tata Sons' board was baseless. There was abuse of power by the directors nominated by Tata Trusts, which led to losses at Tata Sons Group companies. In 2020, Tata Sons and Ratan Tata moved to the Supreme Court and challenged the National Company Law Appellate Tribunal decision before the Supreme Court. The Supreme Court pronounced its judgment in favor of the Tata Group. The bench dismissed all the charges of oppression and mismanagement against the Tata Sons Limited made by the entities owned by Cyrus Mistry. The Supreme Court observed that unless the removal of a person as a chairman of a company is oppressive or mismanaged or done in a prejudicial manner damaging the interests of the company, its members or the public at large, the Company Law Tribunal cannot interfere with the removal of a person as a chairman of a company in a petition under section 241 of the Companies Act 2013. The court held that sections 241 and 242 of the Companies Act 2013 do not specifically confer the power of reinstatement. Therefore, the Supreme Court set aside the December 18, 2019 order of the National Company Law Appellate Tribunal to reinstate Cyrus Mistry as the executive chairman of Tata Sons. Dear students, with this we come to the end of today's lecture on the National Company Law Appellate Tribunal. In today's lecture, we try to understand the working of the National Company Law Appellate Tribunal. We try to understand its constitution, its jurisdiction and its powers. Hope you enjoyed the lecture. Stay blessed.